Most people are terrified in court, but what if I told you that suing a debt collector is often simpler than you think? In this video, I'm going to be breaking down the step-by-step process of using arbitration and small claims, and how to exercise the due process, how to stop getting lost in semantics, and how to stand in truth without fear. So without further ado, thank you guys for watching this video. This is probably going to be one of the most powerful videos that's going to get you over the edge when it comes to private banking and debt discharge. Thank you guys for watching once again. If you're brand new, hit the like button, hit the subscribe button, turn on those post notifications. We just hit 42,000 subscribers. We're on the way to 50K, man. Thank y'all for all the love and support. The second thing I want to cover, go ahead and understand that this is not legal advice. This is not financial advice. Remember to go online and do your own research, okay? Everything that I may say may sound good. Just go research it yourself. Got that? Perfect. Now, my object, of course, is to position you to actually take action, okay? See, knowledge is not power, okay? It's potential power. The potential, if you take action on that knowledge, then knowledge plus action, that equals power, okay? The right action, all right? So let's dive into it. The first thing I want to cover is the mindset shift that you need to have, okay? Because the biggest reason why we don't decide to go to court, we may know the exact process, but and this goes for some of the people that I've been working with, I could tell you what letter to write. I can even help you write the letter. But at the end of the day, your next question is, what do I do next? What do I do next? Take them to court. You know what I mean? Oh, they haven't complied. Take them to court. Have you built enough evidence? Are you confident in your evidence? So again, understand the mindset shift from fear versus honor. If you win, you win. If you lose, you lose. You learn. If you lose, you learn. Okay? So I want you to understand that courtrooms are designed to intimidate. Judges are in robes. They use legal jargon and procedures you don't fully understand, and most people walk in already defeated. Okay? But remember, you are not powerless. The Constitution and consumer laws guarantee you due process. Okay? You have that fundamental right. The right to be heard, the right to demand proof, and the right to enforce your claims. So there, again, everything that you will be doing, you are well within your right to do it, okay? The key is not being emotional. Debt collectors feed on fear and anger, and when you show up calm, collected, and in honor, you shift the energy. In honor means you acknowledge the process. You don't run from obligations, and you use truth backed by evidence instead of arguments or excuses. All right. The courtroom isn't a battlefield. It's a venue for remedy. And once you reframe it that way, the fear melts away. I want to dive into the fact that moving in honor, if you are moving in honor, you have nothing to worry about, because think about it. If you don't go to court, you'll end up paying the debt. If you do end up going to court and actually have a chance of not paying the debt. OK, but if you lose, guess what? You're going to pay the debt anyways. You get what I'm saying? Oh, filing fees, attorney fees, probably extra 100 to 200, 300 bucks, depending on the debt. Wouldn't even amount to what you already have to pay. Okay? And it's the emotion that's stopping you. Oh, what if I lose? When you are moving without emotion, you don't care whether you win or lose. Okay? You will feel good about being able to stand up for yourself and have an opportunity. You know what I mean? A lot of people think that they don't have an opportunity in court, that they're going to just shut them down. But the reality is that's not the case, okay? Some courts would do this, and yes, they do work together. Yes, it in some way is, the odds are against you. You aren't favored in that aspect. But the underdog can always win, okay? You never know what can happen, all right? So try, all right? If you have nothing to lose, try it, okay? And the reason why I focus on understanding the knowledge is so that you don't have this fear, so that you fully understand what moving in honor is, okay? Because, again, people think debt discharge is running from obligations, but the reality is it's really not, okay? If anything, you're doing exactly what you need to do, okay? So no, you're not running from your obligation, okay? As long as you have the truth, and you can back your truth up by evidence, then you really have a stance. So don't move in fear. Okay, and the only way that you cannot move in fear is having the knowledge, right? That give you the confidence, knowledge about moving in honor, and how if you know that what you are doing is rightful, lawful, okay, legal, and you can back that up, you have nothing to worry about. But the people that are fearful are the ones who don't do these next couple of steps that I'm about to talk about and don't understand these next couple of steps, okay? At the end of the day, you can know how to do conditional acceptance, do the administrative process, but people I've spoken to will do that entire process, get to the end and say, well, they didn't discharge my debt. And the thing I will ask them is, you know what I mean? Have you filed a claim? Have you filed a case? No, I haven't. I don't know what to do next. But then you'll read their letter and it says that if you don't adhere to my demand, then I will sue you. So I'll ask, why haven't you sued them yet? You know, it looks like they haven't complied. They didn't answer the questions that you asked them. They didn't adhere to your presentment, which will put them in dishonor. Your case is a case of them moving in dishonor. Why haven't you taken them to court? Because probably we're still in the asking for permission. But when you take them to court, you are initiating, you are moving proactive. You're not reactive. So in order for you to be less fear-based, you have to understand the process. And one of the first steps before you go to court is to build a case before you sue. And I don't care how long it takes you, right? People want to, okay, I can say, all right, you send in you go through the administrative process, you send in your debt validation. After the debt validation, you take them through that administrative. Well, before we do that, you send in your debt validation. They may validate the debt, which they won't. Then after that, you send a tender in honor, okay? You use UCC 3-603 to be able to enforce it. And then through that, you are enforcing it through notices and affidavits, certificate of non-response, fault and dishonor, opportunity to cure. You're literally enforcing your presentments through your administrative process, okay? And you can honestly do this. As soon as they dishonor you, you can go and straight try to take them to court. But I would never recommend against that. I will always tell you to build as much of a case as you can, because if you can build up a case of harm, then it just makes your case much better. Don't rush trying to get your evidence. Okay, I'm gonna send a couple of them. I'm gonna follow these steps that Nicholas say, and then when I follow these steps that Nicholas says, then I'm gonna be ready for court. But the same people will take the things that I said, maybe for literal, like the exact templates, send it in. They don't even understand what they sent in and what they should be expecting. And at the end, at the end of the process, they're not ready to go to court because they don't even understand what they were asking them for. You know what I mean? They don't even know the legal merit behind it. They don't even know what they just did. They just sent letters and hope for something to happen. The whole point of you sending these letters that I talk about is to build a case of dishonor, non-compliance, willful non-compliance, negligence. Okay? So courts run on evidence and records. That's why you start building your case long before you ever file. You have to have long-term thinking. If you're about to foreclose soon, this is not the process that's going to immediately just like get you remedy. You know what I mean? It maybe be able to delay and get you in a position to be able to negotiate, but this is not something that you just, damn, I'm about to foreclose in the next month. Let me try to do this process and hope for the best, especially if this is your first time doing it. Okay? And I bring that up because a lot of us are going through stuff like this. And we wait until things get uncomfortable to start trying to do things that would make us even more uncomfortable instead of doing it while we are comfortable. You know what I mean? Like if right now you have nothing that you have to worry about, this is the time to learn as much as you can in case you do get in that position. Now I'm rambling on. So because they base it off evidence and records, you want to use the administrative process for your foundations and to substantiate your claim. You want to send a debt validation. According to 15 U.S.C. 1692G, you can demand proof of the original contract, the amount, and the chain of ownership. The chain of ownership is super important because it'll let you know who the legal holder in due course. This is why debt validation works. Okay, debt validation works best for third-party debt collectors than the actual creditor. Okay, and I put this because I'm just talking about before they sell it off to a collection agency. So debt validation may work best for collection agencies or third-party debt collectors, but it may be able to start bringing up a question so that you can then dive into conditional acceptance. Conditional acceptance is probably best for the original creditor, okay? Because they're a deeper questions that you're asking, and essentially you are not moving in dishonor. You're saying, hey, I'll accept your claim if you can prove X, Y, and Z, okay? And if they can't prove it, then they dishonor. You see how I'm like putting them in a position to dishonor? Because I'm not about to go in there, argue whether the amount should be in the account. Y'all can type however much numbers y'all want in my account all you want. I'm just trying to have a one-on-one negotiation, and I'm moving in honor, okay? I'm trying to perform on my contract, and you want me to pay. But payment in law means a performance of a duty, okay? So I'm just trying to perform. I am trying to pay, all right? For those of you guys who don't know what payment means, it says payment in the Black Law Dictionary, the performance of a duty, promise, or obligation, or discharge of a debt or liability by the delivery of money or other value, okay? Your negotiable instruments can be an other value, okay? Notice of fault, dishonor, and estoppel, okay? These are documents showing that they ignored or they failed to respond. So if you send a debt validation letter, conditional acceptance, it's not that you'll keep repeating the same letters. You're going to send a letter pretty much like taking them through a process. If after I've asked you questions, you don't respond or you don't respond sufficiently, I'm going to let you know that you have created a fault and you have dishonored me. You know what I mean? So I can build a record of your non-response and any other letter that I feel like I need to add, any other evidence, any other questions I want to ask, any other things I want to expose. I'm going to put it in letter form and send it to them and let them know about my newfound evidence, whether they have defaulted, whether they have securitized. I'm going to send all of that to them. I'm going to send everything certified so I can get a return receipt and have evidence of me sending it to them and them receiving it. Okay? So you have undeniable proof of you attempting to perform, you attempting to move in honor. You want to keep a clean paper trail, copies of letters, receipts, credit reports, responses, or lack of responses. This record is your evidence bundle. So when you step into court arbitration, you don't show up with opinions. Oh, I think it should go this way, or I think it should go that way. You show up with a file proving that they failed due process. That is your argument. Not that you need to pay or whatever the case may be. Can we talk about the due process that they failed? When I had a disagreement on a contract, they didn't allow me to challenge that contract. Between them, I had to go through this whole entire challenge. And as you can see, I've reached out to them multiple times, attempted to ask them questions that I, under the USC and under the UCC, can ask, and they decided not to answer. So what jurisdiction do they fall over that they don't need to answer these questions? Okay? So this right here is super important before you even decide to go to court. And if you don't know how to do that, tap into the school community and watch the 750 Accelerator and complete that guide and understand the administrative process. You get what I'm saying? When you look, for those of you guys that's already there, and you guys look at templates and send templates, read the templates and understand them, understand them. Look up the terms. Actually focus on what it is that is going to help you understand it even more. Because those templates and those letters that I create are not just for use. They're actually for educational purposes only. So technically, you really shouldn't just be sending templates. You really should look at the letter, read it. And if you read it and you don't have a understanding of what the whole purpose of it is, don't send it. You get what I'm saying? And if you look at the choices and it says, okay, bet, I need to ask them for proof of securitization, a 1099, I need to ask them for their original certified wet ink signature. Look these particular terms up and figure out exactly what that will look like. You know what I mean? Chain of ownership, what does that look like? You know? Don't just send it and hope that they're gonna do it. You know what I mean? Because when they don't do it, your next question is, well, what do I do now? You put at the bottom of the paper that if they did not respond, you would potentially take them to court, or their tender has been honored, or their refusal means discharge, or you said that they acquiesced, or you're going to assume certain things. So why would you be asking me, what do I do next? Really think about that. You're not reading the letters. Okay, you're just taking the templates and sending it out. That's lazy, okay? So after you have built the case, now it's the deciding between small claims or arbitration, okay? Now, first things first, when deciding between arbitration and small claims, depending on your state, there are different fees associated with it when it comes to small claims. Places like California, I think you can sue up to $20,000. and it costs up to like $150 to start to file in small claims. And then there's places like Minnesota, Tennessee, you know what I mean, where it may be a small claims of $7,000, you know, and you know, the numbers are much lower. So the filing cost may be different, but the process is the exact same, no matter the state. Okay. And then in arbitration, that's pretty much universal. They pick an arbitrator. It's not a judge, maybe a retired judge or an attorney. And essentially that's more private. Small claims is public. Arbitration is private. Arbitration runs much faster than small claims, but small claims has less, I'll just say that it has less risk like arbitration. Okay. Because I think that when it comes to arbitration, most times those companies pick arbitrators that aligns with them. If they are picking, that's why you want to file. And in small claims, it's kind of more of an even playing ground, and they can go by, and that right there is something that is going to be more like a paper trail. Even though they both are, small claims just going to be in the court record and it's public. Okay. So I'm going to talk about small claims first, and then we're going to talk about arbitration. So small claims, why small claims? Because it's built for ordinary people. No attorneys are usually required and the costs are low. Cases move pretty fast. The process is step by step. You file your claim. In your complaint, you list the violations, whether it's the FDCPA harassment, failure to validate, inaccurate reporting, etc. Be specific and cite the statutes violated and request statutory damages, often $1,000 per FDCPA violation. So if they ignore your letter, $1,000. If they fail to validate, $1,000. And every time they do it, it's $1,000. So let's just say they fail to do it over 3 letters. That's $3,000. Okay. You want to attach your evidence, your debt validation letters, your proof of mailing, any continued collection attempts without validation, their responses. Okay. Any other evidence, any other cover letters and letters that you sent to them, conditional acceptance, affidavit of truth, certificate of non-response, anything. The more evidence you have, the easier it is for you to communicate your claim, and you'll have it right in front of you. Okay, I sent this. Okay, well, they have a response to this, but what about this response when I responded in this way? Because we've had this conversation already. As a matter of fact, I've been trying to have this conversation with them this entire time, and they was ignoring me because for what reason? Because are they bigger than me? No, they're not. Okay, so your evidence, file your claim and attach your evidence. Number 3, serve the defendant. This can be done via certified mail in some states or by a process server or a sheriff. It costs about $40 or something like that, $20 to $40 in some states. You can hire a friend to do it. Someone has to serve them at their address. Okay. And then number 4, prepare for your hearing. Organize your evidence chronologically. Have copies for yourself, the judge, and the defendant. 3 copies of everything down the middle. Okay? And show up calm. State your facts, reference the law, and avoid emotional tangents. Judges respect brevity and clarity. Many collectors don't even show up, and if you win by default, those who often fold when faced with solid evidence. So, if you have the solid evidence, what can they do? Most people go in there with no evidence or don't even understand their evidence or can't even talk about their evidence. They say, I sent this letter. And the judge asks you, okay, well, why did you do this? Why didn't you just pay? Well, Your Honor, this is why I didn't pay. Because I asked them to provide proof that they are the legal holder in due course, and they still haven't provided me that. And I'm going to keep saying that, okay? Doesn't UCC 3-305 give me the ability to assert myself against anybody who I believe is not the legal holder in due course? Does anybody who's not the legal holder in due course have a right or the authority to collect? No, they don't. When I asked them for the chain of assignment and they didn't give it to me so I can see if they're the legal holder in due course, they didn't give it to me. So for whether they're the holder in due course, if they was, why didn't they just present that evidence to me? So yes, I agree. If this was an actual loan, I should pay. But it wasn't a loan. You and I both know that. So again, I'm not like moving with emotions. I'm just stating the facts and the truth. Can y'all rebut my truth? Can you disprove my truth? That's all I'm asking for. If you can disprove my truth, then I will pay. It's not a bad argument. And here's my evidence of me literally trying to have this conversation with them this entire time. Okay? So, small claims. Okay? You can do this by yourself. Maybe smaller amount, but you can do this by yourself. Now, arbitration. Arbitration clauses are hidden in most credit card agreements and debt contracts, and collectors put them there thinking it protects them, but it actually can protect you too. This is why arbitration can work in your favor, maybe much better than small claims. Collectors must pay filing and case fees that can run into the thousands. Many debts are only a few hundred or $1,000, and it costs them more to fight you than to drop it. And then number 3, arbitration forms like the AAA, the JMS require rules of evidence, meaning your administrative record actually has real weight. Okay? Can't no judge go in there. It's not going to be a judge in there just trying to make the money off the processing or whatever the case may be. So literally, the evidence will actually have some more, it's going to be more effective in arbitration. Okay? But it does cost a little bit more. Okay? Steps to use in arbitration. Number 1, check the contract for an arbitration clause. Sometimes they'll say, well, you have to do it on this place and this location, whatever the case may be. Sometimes they have like different clauses when it comes to arbitration. And you can easily argue that some arbitration clauses are unconscionable. So that's always hard for me to say. Okay? Check the contract for an arbitration clause. You want to file a demand for arbitration with the name forms. You want to pay a small consumer filing fee, usually under $300. I think it's $250. And present your evidence of the FCRA and the Fair Credit Reporting Act violations, dishonor, lack of validation, and often collectors will back out or settle rather than proceed because of the cost and the risk. Now, if you have a case and you have real evidence, okay, they will probably back out because it's going to be too much money. Not only do they have to pay the arbiters, but they also have to pay their attorneys. And then what if they lose? And what if you potentially are suing them? Now it's like, damn, I need to settle with this person. Okay? So we got small claims, we got arbitration, all right? And you could choose either one. It really depends on your situation. If you're going to go small claims, that's going to be more public, okay? If you want to go arbitration, that's more private. And you can get more money in arbitration. Small claims, there's a minimum. There's no minimum in arbitration, okay? Because you're paying for it, all right? The next thing I want to talk about is the legal merit. For those of you guys who haven't watched me before, okay? The legal merit behind what you are doing is in the Constitution, okay? Under 15 USC 1692, 15 USC 1692, which is the whole Fair Debt Collection Practices Act, which breaks down you having the ability to challenge and validate debts, okay? The different types of harassment when it comes to debt collectors, how they should communicate you when it comes to debt collection, and also what you will be awarded if you sustain any damages because of the debt collector. It's in the Constitution. But then we can go back to the Truth in Lending Act as well. The Truth in Lending Act breaks down the truth about lending, the disclosures. It protects you when you are reaching out to them for information and they don't give it to you. This protects you. It says here that it is the purpose of this subchapter to assure a meaningful disclosure of credit terms and avoid the uninformed use of credit, and to protect the consumer against inaccurate, unfair credit billing and credit card practices. So anything dealing with lending, they have a duty and obligation to provide that information to you. But then we go to the Fair Credit Reporting Act. If you decide to sue a creditor, a credit bureau, okay? Or even the debt collector for reporting things, this whole subsection protects you against their credit reporting. And this is the reason why we do what we do, so that we can get our credit in position. Okay? If we can get our credit in position, then we're going to be able to get funding. But a lot of people look at this and they see all this information, and they hope this is something that they can just learn today, and boom, just start taking action, and they're going to get results. No, you're going to fail sometimes, and that's okay. It's a part of the game. That's how you learn. So the FDCPA requires debt validation, so you have a right to ask for that. Forbids harassment or misrepresentation. It grants $1,000 for statutory damages. Fair Credit Reporting Act protects against inaccurate reporting, requires reinvestigation when disputes have been filed, and violation carry damages and attorney fee recovery. You have a right to due process. According to the Constitution, courts cannot enforce claims without proof or standing, and a collector must show the original contract, chain of title, and accurate accounting in order to prove their claim. Okay? There are numerous case laws out there that show debt buyers that often cannot produce the original signed contract or proper assignment, and without it, their case collapses. Legal merit isn't about arguing loopholes, it's about calmly applying the statutes and precedents the court already recognizes. So people go in there with the sovereignty conversation, or they go in there and they try to have a theoretical or emotional response when it comes to this. Oh, I fell on hard times, whatever the case may be, or, this is God-given creation. That doesn't work. Sorry, but that doesn't work. Okay? So let's just go ahead and bust some of the myths, hopefully to overcome that fear that you have with going to court. And the only reason that you have fear is because you just won't do the research and you're not ready for the risk, and that's okay. That's okay. This is why I post on a consistent basis. Hit the like button, hit the subscribe button. 90% of y'all watch my videos and don't hit the like button or the subscribe button. So go ahead and do that right now. All right. So here's the first myth. You can't beat debt collectors in court. Okay. Reality is debt buyers win by default because consumers don't show up. And when you don't show up prepared with evidence, they often fold because they lack proof. Okay. As long as you show up with your evidence and you have done building and you built your case prior, then that is how you would beat a debt collector. You're not going to beat a debt collector by just showing up or being reactive. Okay. Or even not showing up. Number 2, arbitration always favors the creditor. The reality is arbitration is expensive for collectors and they rarely want to spend thousands to chase a few $100 debt. Many cases get dismissed once you invoke arbitration. Okay. So again, sometimes money will help you win. Sometimes just as simple as that. And this is why you will file to be able to bring up those questions. Judges will laugh if you bring up consumer laws. Reality is judges actually respect statutes. And if you calmly cite the FDCPA, 15 U.S.C. 1692G, or the Fair Credit Reporting Act, 15 U.S.C. 1681I, which deals with the consumer reporting agencies, and I'm only talking about debt collectors and I'm talking about the consumer reporting agencies, because you will also find yourself using small claims to arbitration for them as well. And as long as you present your certified mail receipts, you looked informed and credible. As long as you know what you are talking about, they're not going to take advantage of you. And as long as you are respectful, you know what I mean? You don't seem like you're trying to get over, all right? But you seem as though as you know the game. They have to respect it, okay? And another myth, court is about emotion and who argues the best. Reality is court is about records and facts. Okay, whoever has the cleanest evidence trail and can show dishonor usually wins. And most times you are not that person. Most times you may think you have evidence, but you don't know how to talk about it. You don't even know what it is. You know what I mean? So when you come at the last second after you've done this and said, I've been doing this for years and it didn't work, whatever the case may be, it's probably because like you truly didn't know what you were doing. And that's okay. Next time, and this is what you have learned, let me actually prepare for court. Let me not just send letters. And then because I've sent letters over 4 months and I'm ready to get results, now I'm going to go ahead and file my claim. But then I'm going to go to court and I can't even communicate with my spouse and argue my case with my spouse. Okay. So this was actually a longer video than I thought it would be, but at the end of the day, you can win. Stop fearing court. If you build a case, you substantiate your evidence, you could be able to speak your claims. If you genuinely feel like that, then you're ready for court. If you're not, if you don't feel that way, you're not ready for court. You know what I mean? Don't let your bills get out of whack if you don't know this process. It's just that simple, okay? Don't get into contracts with the hopes that you'll potentially discharge it. Or just because you have the knowledge that you can discharge it, don't get into contracts because, oh, later on I may discharge it. No, don't do that, okay? You may set yourself back. If you're afraid to go to court, don't try to do like any process that'll you'll end up having to go to court in order to get your full remedy. You know what I mean? This is for the people who genuinely want to get results. This is for the people who genuinely want to win and are ready to overcome that fear of going to court. I don't care how many letters you send. They're not gonna, if they don't do it after 4 or 5 letters, they're not gonna just like do it just because you're sending letters. Some things may stop, some things may cease. You may not get phone calls anymore. But all they're doing is you playing a waiting game too. When you stop, 3 months go by, they're gonna have you default and they're gonna take you to court. The only reason they do it fast because they know they do this with a lot of people. But this will be your first time. Think long term, okay? Stop thinking this is something you're gonna send some letters and you're gonna try to rush them, but you're not even ready. You know what I mean? Be ready, be prepared. Don't just do it just because. And if you're not ready, if you're not prepared, don't do it. I'm here to really give you the truth and take the emotions out. If you're gonna be emotional, don't do it. If you're gonna get upset if you lose, don't do it. If you're trying to do this because you wanna be a part of the crowd that does private banking and debt discharge, stop it. Stop just trying to be a part of the crowd or trying to sound cool, because this is real life, all right? And I don't want anybody who watches my videos who don't fully know how to do it, go and try to apply this to your utility bills and all that. Your lights get cut off, your car gets repossessed, your house get foreclosed on, or whatever the case may be. This is for the people that are actually doing their own research, and and maybe they just need this video, okay? Like I said, knowledge is not the power, it's potential power with action. And some people want me to do the actions for them in my videos, but it's only so much that I can do. So if you think about it, nobody's talking about this on YouTube. So if you're truly in it, the juices get the flowing, and you're like, oh, okay, this does confirm, okay? Oh, this is where I went wrong, all right? Thank you guys for watching this video. I had a little ramble, little rant. If you want to learn more about this and how to sue debt collectors, how to sue creditors, credit bureaus, it's in my school community for only $27 a month. If you need work with me one-on-one for some of those matters, tap in and apply for my mentorship down below. The link is in the description. Right now, we are also helping people develop personal brands. So if you have a business, you're looking to take your business from 0 to 100,000 followers, be able to get leads into your business, whether you're a realtor, whether you are a credit repair specialist, whether you are a marketing agency, creator agency, whether you own a brick and mortar, okay? If you're an entrepreneur that's looking to take your business and create an online presence, also click that application down below, okay? And lastly, hit the like button, hit the subscribe button, turn on the post notifications so that you get an update every single time I post a video. I love you guys, and if you've gotten this far, comment the word sue in the comment section, and I'll see you in the next one. This video is sponsored by the Fund Yourself Academy. My step-by-step system designed to help you fix your credit, get funding, and build real financial freedom from scratch. If you're tired of feeling stuck, overwhelmed, or just ready to stop living paycheck to paycheck, this is where it changes. Inside the Academy, I break down everything from consumer law secrets that they don't teach in school to how to remove negative items and boost your score, get access to business funding, and start building multiple income streams online. Whether you're just starting out or ready to level up your game and get the bag, this is your playbook. We've got tools, templates, dispute letters, mentorship calls, private community access, and an exact roadmap I use to leave my 9-to-5 and create time freedom. But only for a limited time, you can get access to the Fund Yourself Academy on a free trial basis for the next 7 days. And then after that, you pay less than $1 a day at $27 a month if you like it. No fluff, just facts and just freedom. Go to thefundyourselfacademy.com or hit the link in the description to join now, because nobody's coming to save you, but you can fund yourself.